Hello, it's Philip Taylor speaking from Richmond Green Chambers in London, and this morning I'm looking at a book which has come to us from Oxford University Press. It's got the intriguing title Vagueness and Law, with the subtitle Philosophical and Legal Perspectives. And I think from a jurisprudential point of view it's very interesting. Clearly the word philosophy comes into this too. Now it's been edited by two people, Geert, Keil and Ralf Poscher. And as I say, it's available from OUP. We've given it a title for our book review. Elizabeth and I talked about the book, and we said the product of a 4-year project. The results are not in any way vague for the jurisprudent. And I think that was certainly the conclusion I arrived at when I looked at the book. Let's have a look at it. It's a hardback. There we go. There's the front spine. There's nothing on the back. There is a dust cover, so you've got a lot of information, some of which I've quoted from, which is at the front there, and it tells you a little bit about the editors at the bottom. And then on the back you've got other books in the series, not very many of them at the moment, it's growing, but it's an interesting book. Now, what do we have at the back? It runs to something approaching 336 pages, so it's under 350 pages. The index is by page numbering, so you should find things. It's not a big index, I hasten to add. Quite a lot of people's names in it, which it gives you an indication. It's more chronological and sociological in its structure. And the book itself, of course, you can see there are references at the back of each of the main chapters, and there is footnoting as well. If you go to the front of the book, we've got the actual front cover there. Then you've got the details from OUP as to what it's all about, and then some acknowledgements about the book itself. Then you've got the structure of the book, because this is a book which is edited by two people with contributions. So you've got various parts. There are 3 parts in total. Theories of vagueness and their impact on jurisprudence. Vagueness phenomenon in law, dealing with vagueness in law. And the total number of chapters, 15. And this is the list of all of the people who have contributed to the book. Substantial number of people, some of whom will be quite well known to you probably because of their general standing within the academic community. That's the first page with the introduction. You can see it's got some footnoting at the bottom, and then there is some subheading, various subheadings and so forth as we run through. The book is a complicated book. You can see just in the middle there, this is one of the articles, one of the contributors. Again, looking at a whole range of particular submissions which the individual contributors are putting forward. In other words, the philosophical and the legal perspectives which are explored. I think it's an interesting book. It is at a high level, if I can put it that way. It's not the easiest of reads either, but I thought it was interesting from the point of view of jurisprudence, which is why I decided it would be worth reviewing the book. One of the starting off points which I've found, and I'm really bringing the practitioner element into this, is I can't remember is one of the lines we always dread during live testimony, because it's the very vagueness which can destroy a case. And it's also very useful, of course, when the client is, of course, a liar, although we're not advised to use such words as liar, because its emotive content is enough to anger courts, of course. Thus, vagueness can be a great excuse, or can it? The book opens up this can of worms, as I see it, but it is a great read, again, from a particular series of points of view. But the general view is looking at the problems which we which we encounter, certainly during our legal careers. Now, the title emerged from a 4-year research project. Its aim was to identify and systematize phenomena of vagueness and indeterminacy in different fields of application. In addition, the project set out to examine such related fields as, and they're listed in the book, semantics, ontology and epistemology, whilst developing procedures to deal with blurred boundaries proportionally. The original project title was Dealing Reasonably with Blurred Boundaries, Vagueness and Indeterminacy as a Challenge for Philosophy and Law. Well, that's a bit of a mouthful to say the least. The synopsis, of course, has stated that vague expressions are omnipresent in natural language. Of course they are. And their use in legal text is virtually inevitable. We do get that, and it is a problem. The main contention, then, is that if a law contains vague terms, the question whether it applies to a particular case often lacks a clear answer. And that, of course, is where we have the dilemma when we're having to make the decision. And we also, when you're advising a client, that also is an important factor. So there is a link here directly between the practitioner element and the more general philosophical approach. So one of the fundamental pillars of the rule of law is legal certainty, and the two editors, Keil and Poscher, conclude that the determinacy of the law enables people to use it as a guide and places judges in the position to decide impartially. They say, quote, vagueness poses a threat to these ideals, and in borderline cases, the law seems to be indeterminate and thus incapable of serving its core rule of law value. Now, the editors continue writing that in the philosophy of language, vagueness has become one of the hottest topics of the last 2 decades. Linguists and philosophers have investigated what distinguishes seritical vagueness from other kinds of linguistic indeterminacy, such as ambiguity, generality, open texture, and family resemblance concepts. All of which, those words, have, or phrases, have different meanings possibly to different people, but you can see the difficulties that emerge. That there is the vast literature which discusses the logical, semantic, pragmatic, and epistemic, I'll get it right, aspects of these phenomena. And that's the quote we have there, which is not, of course, in doubt, unfortunately. Now, legal theory has in the past paid scant attention to the differences between the various kinds of linguistic indeterminacy that are grouped under the heading of vagueness. Here, let alone to the various theories that try to account for these phenomena. Of course, the real problem, in my view, I have to say, is that most of the time when they're vague, it's because they're lying. But I shouldn't make blanket generalisations like this for obvious reasons. But I'm afraid that does generally tend to be what 2 and 2 equals when you're actually dealing with a case. Because one has to be, the shrug of the shoulders and you've not quite got what you want from the client is always pretty indicative. But again, you're not working on that for the basis of this book. Now, the two editors, Keil and Poscher, have usefully brought together leading scholars working on the topic of vagueness in philosophy, and of course in law as well, in other words, jurisprudence. And this book fosters a dialogue between philosophers and legal scholars by examining how philosophers conceive vagueness in law from their theoretical perspective, and how legal theorists make use of philosophical theories of vagueness. And the chapters of the book are, of course, organised, as I've said, into 3 parts. Part 1 addresses the import of different theories of vagueness for the law, referring to a wide range of theories from super valuationists to contextualists and semantic realist accounts, in order to address the question of whether the law can learn from engaging with philosophical discussions of vagueness. Now, part 2 reviews different vagueness phenomenon. The contributions posit that the greatest awareness to different vagueness phenomenon can make lawyers aware of specific issues and solutions so far overlooked. And again, that could be quite a useful mechanism for you. And finally, part 3 deals with the pragmatic aspect of vagueness in law, providing answers to the question of how to deal with vagueness in law. I'd be very interested to explore more of that, and I'm sure many people in the criminal field would, and with the professional, political, moral and ethical issues such vagueness gives rise to, because that unfortunately is the problem. And of course you can't expect to get concrete results and conclusions from this because of the nature of the book, but at least the issues are explored, I think, at a good standard, but an understandable standard for all to read. Let me conclude that vague expressions are unavoidable. That is undeniable as a statement. Vague expressions are unavoidable. It's going to happen. But the conclusions in the book, fortunately, in my view, are not, because it's a great contribution to the continuing debate. And I think, again, this is one of a number of books which we have in this area, which I think does help us to understand more about how we deal with what is a very difficult issue. The publication date is actually cited at 2016, although I'm recording this in the early part of 2017. 2016 is the copyright on it. Let me just open the book in the middle. Second Order Vagueness in the Law by Frederick Schauer. There we go. There's a good example. Bertrand Russell is mentioned. Oh dear. But he is actually mentioned there as a philosopher, of course, not a mathematician. You can see the footnoting. You can see the detail. H.L.A. Hart is mentioned, of course, right at the beginning as well. So all the usual suspects philosophically are there. As I said, right at the back, this continues with Hart to some extent. As I mentioned at the back, the index is actually, a lot of the index is about names of specific people, specific philosophers and jurisprudents in the subject area. So I'd like to thank the editors and the contributors and OUP very much indeed for what I think is a very important book in this area, which is probably not as well understood as it might be. Thank you very much indeed to all concerned. Bye-bye.